Did you know that right now, in April 2026, USCIS has officially resumed processing applications that were completely frozen, and thousands of families just like yours may finally have a real shot at securing their legal status in this country? If you or someone you love has been waiting, worrying, and wondering whether there is still a path forward, I want you to take a deep breath, because today's video is going to feel like that long-awaited phone call you have been hoping for. Stay with me, because what I am about to share with you could genuinely change everything for your family, and I do not want you to miss a single word of it. If this kind of information matters to you, please hit that like button right now, subscribe so you never miss an important update like this one, and drop a comment below telling me your situation, because your story matters, and this community is here for you. Now, let us get into the heart of what is really happening, because the immigration landscape in the United States right now is moving fast, and staying informed is truly one of the most powerful things you can do for yourself and your family. Think of it like this: imagine you have been standing in a very long line at the bank for what feels like forever, and suddenly the manager steps out and says, "We are reopening 2 more windows." That is essentially what USCIS just announced, and understanding what it means for you personally is exactly what we are going to unpack together today. On March 30th of 2026, USCIS made an official announcement that it would resume processing certain naturalization applications, those are the N-400 forms, as well as some asylum applications that had been sitting in a kind of administrative limbo. Now, these were not just any applications. These were cases belonging to individuals from what USCIS is calling non-high-risk countries, meaning countries that were not flagged under the stricter vetting protocols that had been put in place earlier. If your application was among those that had been paused, this is genuinely encouraging news. It does not mean the process will be fast, and it certainly does not mean the doors are wide open with no requirements, but it does mean that the gears are turning again, and that is something worth paying very close attention to. Now, you might be wondering, what exactly does regularizing your status mean, and does it apply to your situation? That is a wonderful question, and I want to explain it in a way that is crystal clear. When we talk about regularizing immigration status, we are mostly talking about something called adjustment of status, which immigration folks sometimes shorten to AOS. Simply put, it is the legal process that allows certain individuals who are already living in the United States to apply for a green card, that precious document that gives you lawful permanent residence, without having to leave the country and go through the consular process abroad. For many families, especially those with deep roots already planted here, this pathway is nothing short of life-changing. But here is where it gets important: adjustment of status is not a one-size-fits-all solution. There are specific legal requirements that must be met, and the pathway available to you depends entirely on your individual circumstances. Let me walk you through the main categories so you can get a clearer picture of where you might stand. The first and most common pathway is family-based immigration. If you have a close family member who is already a United States citizen or a lawful permanent resident, we are talking about a spouse, a parent, or a child, you may have a qualifying relationship that allows you to apply for adjustment. This has always been one of the most powerful and established routes in American immigration law, and it remains very much alive today. Think about the countless families over the decades, the grandparents who followed their children here, the spouses who reunited across borders. This pathway has written so many beautiful chapters in the American story, and it could be writing yours next. The second major pathway is employment-based immigration. If you are working in the United States and your employer is willing to sponsor you for a permanent position, this route may be open to you. Now, this does require that your employer go through a formal process, and it can take time, but for many skilled and dedicated workers, it has proven to be a very viable option. The key here is having an employer who is committed to supporting you through the process, and a role that qualifies under the relevant employment-based categories. Then there are what we call special programs, and these are incredibly important to mention because they protect some of the most vulnerable people in our communities. One of the most significant is VAWA, the Violence Against Women Act, which, despite its name, actually extends protections to men and children as well. Under VAWA, survivors of domestic violence who have a qualifying relationship with a U.S. citizen or permanent resident abuser may be able to self-petition for immigration relief, even if they entered the country without official inspection. This is a deeply compassionate provision of the law, and if it applies to you or someone you care about, please know that there are resources and legal advocates ready to help. You do not have to face that alone. And then there is something quite recent and very worth discussing, a court ruling from April 2026 that has significant implications for a specific group of individuals. Do you remember hearing about the CBP One app? That was a program that allowed certain individuals to schedule appointments at ports of entry and request parole, meaning a temporary, legal authorization to enter and remain in the United States. Well, earlier this year, that program was shut down, and many people who had entered under CBP One parole found themselves in a state of legal uncertainty. However, a federal court has now ordered the government to restore parole status for certain individuals who entered through that program. This is a developing situation, and it is moving quickly, but the bottom line is this: if you entered through CBP One, your case may have just received a significant legal lifeline, and you should speak with an immigration attorney as soon as possible to understand what this ruling means specifically for you. Now, let us talk about something that affects everyone in the pipeline right now, regardless of which category you fall under, and that is the issue of enhanced vetting. USCIS has implemented new rules involving stricter social media screening and cross-referencing criminal databases for many immigration benefit requests. What this means practically is that the application process has become more thorough and, in some ways, more demanding. This is not meant to frighten you. The vast majority of people applying have nothing to worry about, but it is important to be aware of so that you go into the process with clear eyes and thorough preparation. Working with a qualified immigration attorney or accredited representative is more valuable now than ever before, because even small details on your application can have significant consequences. Speaking of details, let us touch on the financial side of things, because for many families, cost is a very real consideration. As of March 1, 2026, premium processing fees for certain forms, specifically the I-129 and the I-140, increased to $2,965. Premium processing is an optional service that allows USCIS to expedite review of your petition within a guaranteed timeframe, and while it is not required for most applicants, it is something to factor into your planning if speed is a priority for your situation. Regular processing fees have also seen adjustments, so it is always a good idea to check the official USCIS website or consult a professional to make sure you have the most current fee schedule before you submit anything. Now, for those of you tracking green card applications, and I know there are many of you, here is a very practical update you need to know for April 2026. USCIS has confirmed that applicants must use the dates for filing chart from the official visa bulletin when submitting both family-based and employment-based adjustment of status applications this month. This is something that changes month to month, and it matters enormously because submitting your application in the wrong window can cause unnecessary delays or complications. The visa bulletin is published by the U.S. Department of State, and it is publicly available online. But if reading visa charts feels like trying to decode an ancient map, please do not hesitate to reach out to a trusted immigration professional who can translate it into plain, simple language for you. Throughout everything we have discussed today, one thread runs through it all, and that is the importance of staying informed, staying prepared, and not giving up. The immigration system can feel overwhelming, and there are moments when the process seems impossibly slow or complicated. But the people who navigate it successfully are almost always the ones who kept asking questions, kept showing up, and kept moving forward even when the path was not perfectly clear. You have already taken a meaningful step today simply by watching this video and seeking out accurate information, and that matters more than you might realize. As we wrap up this portion of the video, I want you to hold on to one key thought: the doors are not closed. They may be narrow in some places, they may require patience and careful navigation, but they are open, and with the right knowledge and the right support, many families are finding their way through. Coming up next, we are going to bring everything together and talk about the most important next steps you can take right now, so do not go anywhere, because the best part of today's conversation is just ahead.